All right, good morning, ladies and gentlemen. My name is Judge Law, and we are going to begin with our state all-purpose calendar. This is with the State Court of Fulton County. It is a misdemeanor calendar in which individuals whose misdemeanor cases have already been accused, bonds have been set. And today we are going to get a status of the calendar to see whether the individual defendant wishes to enter a plea of guilty and in exchange for a recommended sentence, or whether the plea would be not guilty and the case will be further noticed for trial. Some of the other issues I'll be addressing are such matters as bond modifications as well as probation revocations. If you're a defendant charged with one or more misdemeanor offense, please remember that you have a right to remain silent. Anything you say in open court, even this virtual recorded proceeding, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you from our public defender's office or from our conflict defense list. All right, good morning, courtroom 2, Mr. McLean, Mr. Haddad, and Mr. Murphy. Mr. Murphy, you have a case on the regular SAP as well?
Yes, I have position 14.
All right, thank you. All right, courtroom 2, who do we have? Deputy, who's that, please?
Yes, it's Officer Norris, Your Honor.
Good morning, sir. And who do we have?
This is going to be Mr. Townsend, position number 37.
37. That's Mr. Haddad's case. And Mr. Haddad, have you had an opportunity to speak with him already?
I have, Judge. This is going to be a negotiated plea, Judge. And
All
I'll
right.
submit the paperwork after court.
All right, thank you, sir. This is State versus Anthony Townsend. Mr. Townsend, your case number is 24 CR 168B, in which you were accused of theft by taking. I've reminded you of your right to remain silent, and your attorney is Mr. Haddad. This is going to be a negotiated plea hearing. In other words, you are willing to enter a guilty plea in exchange for a recommended sentence. So may I place you under oath, please? Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Pierre Thomas, good morning. And,
Good morning, Your Honor.
and what's the state's recommendation for Mr. Townsend?
The state's recommendation on the case involving Mr. Townsend is the defendant is to serve 12 months on probation, to serve 60 days in custody. Credit for the 13 days that he's already served. Looks like he was booked in on January 6, 2024. For the balance to be probated, for him to stay away from 844 Cleveland Avenue, East Point. That is a Walmart location. For him to have no further contact with the Samantha Littlejohn, for him to complete an anti-theft course, and for restitution to remain open for 30 days. And if we could sound for Ms. Littlejohn in accordance with Marcy's law and get the defense to stipulate to venue, factual basis, and ID, that'd be greatly appreciated.
All right. Mr. Haddad, do you so stipulate?
We do.
All right. Samantha Littlejohn. If you're present, please unmute. I don't see anyone by that name. All right. Mr. Haddad, does your client accept the terms?
Yes, Judge. We're just asked respectful request the court to follow the negotiated plea, Judge.
All right. I didn't hear anything about restitution, so that's not going to be pursued, correct, Mr. Pierre Thomas?
Well, for it to be left open for 30 days.
Oh, okay. Mr. Townsend, have you consumed any alcohol or medicine recently?
No, ma'am.
And have you understood what's going on so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to enter a guilty plea today?
No, ma'am.
If you decide to enter a guilty plea, you do understand that you have additional time to serve at the jail before you report to probation. Is that your understanding?
Yes, ma'am.
And also, do you understand that by taking this plea, you would have to give up your right to a trial before a judge or a jury, to go back to court, to be able to confront your accuser, challenge the witnesses and the evidence brought before you, and also have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by taking?
I plead guilty.
Your sentence is 12 months to serve 60 days, credit for time served 13 days. You have additional time to serve at the jail, after which you will report to probation on the first available business day, which will be a Monday, a Tuesday, or a Thursday. The probation office is located at 13, yes, sir?
My question is, do I have to pay probation fees?
Well, most likely you do, yeah. When you're on probation, you pay
Well,
probation fees.
I'm homeless, I don't got nowhere to stay. I'm really homeless, I don't have nowhere to stay. I was staying at 1247 Short Hill Drive, but my sister passed away back in November.
Where do you live?
I was staying at 1247 Short Hill Drive in Riverdale, but my sister passed away in November.
Well, you're gonna have to report.
I can report, I mean, if I gotta pay, I have to pay something.
Mr. Haddad, have you explained to him probation and that he has to complete the class as well as stay away from the location? That's why he's on probation.
I did, Judge, and he had provided me another address where he was staying, so that's news to me as far as what he indicated to the court in terms of homeless. But I mean, are you good with, you wanna take the plea?
Yes, I'm cool with the police, man.
All right. As I was saying, you would have to report to probation once a month at 132 Mitchell Street in downtown Atlanta. That visit is once a month. That is the consequence for, I mean, that's the sentence that you will have to complete in order to, for me to accept this guilty plea. Do you understand? You are also to stay away from the Walmart at 844 Cleveland Avenue in East Point. You're not to return to that Walmart. Have no contact with Samantha Littlejohn, and you must complete an anti-theft class.
Do I have to pay for that?
The anti-theft class, you would have to pay for that, yes.
How much is that?
I think it's gonna be about $50.
Damn, okay.
You're gonna have to find a job, pay your probation fees, and do your class.
I'm on probation for a year.
You're on probation for a year, yes. Every
All right,
month that
thank
you
you.
report, you pay probation fees.
So do I report, what, February?
You report on, this is 18th, so you will report on January 25th. Oh, sorry, no, you report on the first business day after you finish your jail time.
So when you get out, the next day you go, okay? Thank you, Judge.
All right, thank you. Oh, by the way, restitution is open for 30 days.
Yes, Judge.
You don't go with SARS. Your Honor, can we go to the probation revocation calendar?
Which number?
Can we go to, hey, we gotta get him out of here. Go to position 5 and 6, Mr. Hill.
Officer Allison, good morning.
Good morning.
All right, may I place
This
you on
is
the oath?
Mr. Hill.
Yeah, Rashad Armand Hill.
Okay, because they had said 5 and 6, so I'm just making sure.
Okay, Officer Allen, may I place you on the oath? Do you solemnly
Yes.
swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you, officer. All right, we have Mr. Rashad Armand Hill, who's represented by Mr. Haddad. Mr. Hill, I've already reminded you of your right to remain silent. We are addressing a probation revocation in one of the cases, which is 23 CR 4832A, in which you were convicted of simple assault, family violence, and willful obstruction of an officer. You have a revocation hearing. In other words, there is an intent to revoke your probation and have you serve out the rest of time in jail. The revocation here case is 24 PV number 2. And we're going to hear from our probation officer, Officer Allison, as to the reasons why they're seeking a revocation. Officer Allison?
Mr. Hill failed to pay probation supervision fees in a total of $80, victim crime funds in a total of $18, failed to report as directed on September 11th, 2023, September 25th, 2023, and October 10th, 2023 did not complete domestic violence intervention program, failed to complete ADET, and failed to complete behavior modification course. He has 282 days remaining on this case. Probation is recommended to continue on probation and enrolled in domestic violence within 30 days.
When was the conviction date?
The conviction date was August 22nd, 2023.
August 22nd, 2023, and he's not completed any of the requirements for his sentence?
No.
Okay. Mr. Haddad, why shouldn't I just keep him at jail? Just be done with the time.
I mean, I understand that the court's position, Judge. I don't really have a legal excuse to offer to the court, in all honesty.
He has about 144 days left.
So
Serve out that rest of the time and then he's done.
I understand that the court, nonetheless, on my client's behalf, Judge, you know, I think there's still enough time for him to complete the classes what he was supposed to complete beforehand. But ultimately, Judge, it's entirely within the court's discretion as to what to do, what's appropriate in this case. My client had reported to me that he had been working with the Atlanta Peach Movers, although it's not necessarily stable. He's 44 years of age, Judge. He's completed high school. But, you know, if the court is looking at a legal excuse, I don't have one to offer to the court, Judge.
All right. I'll accept the state's recommendation, and he has 288 days left on probation. Does he have any holds at the jail presently?
Your Honor, he does. I've reached out to his felony attorney, Judge. He's not scheduled. He does not have he's on no bond status right now. And I apologize, Judge. I got the cases. I don't remember right offhand what the felony is, but he's not going to be released right away, Judge.
Okay. Also, Allison, we're going to toll his probation period while he's at jail. He will have 288 days left to serve on probation while he's once he is released on the felony matter. I don't know when that is, but once he's released, he must report to probation, and he will report twice a month, and he must begin his domestic violence domestic violence classes within 60 days of being released.
Thank you, Judge.
All right. And then he still has to make sure he reports twice a month now. But the option is still available if he wants to serve out the rest of the 144 days in jail.
Okay. All right. Thank you, Judge.
Thank you.
Next, Your Honor, we're gonna go to position 1 and 2 on the probation revocation calendar. Mr. Chambers, Jonathan Chambers.
Your Honor, as he approaches the chair, may I announce that number 2021 on the regular calendar is a negotiated plea. I had announced it as a probable plea.
Right, okay, got it.
There's an add-on, Joshua Fletcher, who is in the Cobb jail. I have handed him his paperwork to read, and when he finishes reading that, I'll be able to interview him.
All right, is that Jackson?
No, that's Mr. Fletcher, Joshua Fletcher.
Okay,
Your Honor.
let me know when you're ready to address that case on Cobb or when they zoom in, okay?
Oh, the guy from Cobb, Mr. Fletcher, is here in the room with us.
Oh, in the room with us, okay, just, I'll let Officer Norris organize that.
Thank you.
Okay, and I'm so sorry again, which position are we on the revocation?
Chambers.
Chambers, got it, position 1 and 2. Jonathan Chambers has got a case 19 CR 5514E in which he was convicted of one or more of the following offenses: DUI, driving under the influence of alcohol per se, failing to report an accident, driving while license suspended, revoked, less safe DUI, and reckless driving. He was sentenced and placed on probation. Apparently, there's been now a case to revoke his probation and serve out the rest of the time in jail. Mr. Chambers, you have been advised of your right to remain silent, and your attorney is Mr. McLean. Officer Allison, you're under oath. What's the reason for the revocation?
I'm sorry, I'm just bringing it up. I wasn't aware that he was an add-on. It's just loading, sorry.
Okay, no problem.
Okay, Mr. Chambers failed to pay court fines and surcharges in the total of $2,678.50. Failed to pay probation supervision fees in a total of $800. Victim crime funds in a total of $180. Failed to report to court as directed on August 23rd, 2023. Did not complete ADET. Failed to complete 240 hours of community service. Risk reduction course, and 2 victim impact panels.
When was the conviction date?
The conviction date was July 10th, 2022. And he has 48 days left remaining on this case. Probation is recommended to revoke the balance.
Right. And Mr. McLean, how many more days has your client been in jail?
He's been here for how many days? 7 days. He's been here for 7 days this time, Your Honor.
Okay. Looks like this is his, he's had multiple probation revocations before. All right. Yes, Mr. McLean?
Your Honor, during the last year, he went to rehab at a place called Oasis. And that was for 30 days. Then he came out and went to another Oasis program that was 90 days, and that was inpatient or outpatient? That was outpatient. So the 30 days was inpatient, Your Honor, and the 90 days was outpatient. Then he went to an aftercare, which I believe was named Summit. And that's a halfway house. So all this stuff, Your Honor, just went out of his head. I'm sorry. It just, So he's got 2 kids, one of whom is 2 months old and the other is less than 2 years old. His family is in Milledgeville, Blairsville, I think, Blue Ridge. They're in different parts, but they're pretty local, and stands ready and realized that it is the right thing to do to pay the fine off. We heard a figure of 22,600 and something.
Oh, no, not that high, sir. Not 22,000, $2,678.
2,600, something like that. And they are prepared to pay that pretty much instanter, like it could be done today. But Your Honor, with 48 days left, he could get an ADET done. He's already been to the treatment that the ADET would indicate, so he probably doesn't need the E. He could do that victim impact panel, and there are 2 of them that he was told to go to, so he could do both because that's less than a day each. He could certainly do the RR. That's only about 4 to 8 sessions, as I understand, would cost a few $100s. He could get that done. He's asking the court to forgive him his complete forgetting of his requirements. Once he did the 30 days inpatient, the 90 days in the one place, and then the rest of the time in the other aftercare, he just blew it, and he doesn't have a legal excuse, but he's asking for the mercy of the court.
All right. Miss Angel Chambers, are you related to this case? If you want to say something, this will be the time to unmute.
Good morning, Judge.
Good morning. How are you related to Mr. Chambers?
I am his stepmother.
Okay, and what would you like to tell me?
John Michael's been in and out of court or in and out of rehab for the past couple of years. He has worked tremendously to get where he is today. We are in support of him, and we are prepared to assist him with the additional requirements of the court, as well
Where will
as,
he be living?
pardon me?
Where will he be living?
He will be staying with his grandmother in Blairsville.
And how is he going to report to probation?
We will make sure that that happens. Either myself, his father, or his grandparents will assist him to get to probation.
Okay. And what about he owes $2,858 presently.
We are prepared to pay that.
Okay. And he has 240 hours of community service to complete.
Yes, ma'am. We will see that he does that as well.
All right. He'll be reporting twice a month.
Twice a month. Yes, ma'am.
Payment must be made at his first probation visit.
So the payment of his probation or the total amount in full?
2000, you got this number? $2,858, which is the outstanding fines, the probation fees, and the victim fund.
Okay. Do we pay that when we come down to the jail to get him, or do we pay that at the first
He
probation?
pays that to the probation officer on his
Okay.
first visit, which will be on Monday. January 22nd,
January
2024, before 3 p.m.
3 p.m. Okay.
And then he reports twice a month, so the probation officer will give him his follow-up dates, and then it will follow up with twice a month.
Yes, ma'am.
He must begin his community service and show proof of completing at least, at this rate, at least 20 hours on every visit.
Yes, ma'am.
And show proof that he completes the alcohol, and bring proof that he has enrolled in the, the Oasis program and the Summit program, and present that to the probation officer. And I will accept that in lieu of the alcohol and drug evaluation and the 2 victim impact panel and the risk reduction.
Okay. Yes, ma'am.
Officer Allison, did we get that?
I just have one question on the last part you said. So the treatment will be in lieu of ADET risk reduction and both victim impact panels, correct?
Correct. Yeah.
Okay.
Thank you, Judge.
He is to continue treatment as directed. I think that's the best thing. If he is voluntarily doing that, that's the best part. But he's required to report to probation twice a month and show proof that he's completing at least 20 hours of community service every time he reports.
Yes, ma'am. Thank you.
All right, so he's going to be a really busy bee.
I'm sorry, can you repeat that?
He's going to be a really busy bee.
Yes, ma'am. He will be, and so will we. But he's on the right track. He needs to.
This is not his first probation violation in this case. This is, I believe it's the second one, and
Yes,
it'll be
ma'am.
recorded as a probation violation. Please understand, if the probation officer reports that he does not show up and does not show up with payment, that would be deemed to be a violation. He might as well surrender himself back to jail.
Yes, ma'am.
All right. Anything else, Mr. McLean?
Nothing else, Your Honor. Thank you.
All right. Good luck, Mr. Chambers. I'm very, very glad to see you have family support. Take full advantage of it. Thank you.
Thank you, Your Honor.
Thank you, Ms. Chambers. You're free to go.
Thank you.
Next, Your Honor, we have position 3 and 4, Mr. Darrell Henderson on a probation revocation.
Mr. Darrell Henderson's got a probation revocation matter, 23 CR 6086A, in which he was convicted of one or more of these following offenses: theft by receiving stolen property, driving an expired or no license, and missing a defaced or having an obscured license plate. He was sentenced, and he has apparently gotten an issue with being on probation, and there's a revocation hearing for case 24 PV 91. Mr. Henderson, you've been advised of your right to remain silent. Your attorney is Mr. Haddad. And Officer Allison, what's the reason for his revocation?
Mr. Henderson failed to pay probation supervision fees in a total of $400, victim crime funds in a total of $90, failed to report as directed on October 13, 2022, November 14, 2022, and January 26, 2023, failed to complete 40 hours of community service, did not complete a shoplifting course. He has 43 days remaining on this case. Probation is recommended for time served, case closed.
Mr. Haddad, is that acceptable to the defense?
Yes, it is, Judge. We respect request to follow the recommendation.
This will be marked as a probation violation and the remaining time will be commuted to time served, and that closes out this case. Thank you.
Judge.
Next, we're gonna go to position 9 and 10 on the probation revocation. Mr. Michael Wilcox.
Mr. Michael Wilcox has got a case in which he was convicted of either either or all of the following charges: criminal trespass, theft by shoplifting, public drunk, and the case number is 23 CR 4114Y. He was sentenced to probation and there's been an alleged violation. The case number is 24 PV 92. Mr. Wilcox, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. Officer Allison, what's the basis for the revocation?
Mr. Wilcox did not fail to pay probation supervision fees in total of $120, victim crime funds in a total of $27, failed to report on August 10th, 2023, August 17th, 2023, and September 11th, 2023, failed to complete ADET, and did not complete a shoplifting course. He has 254 days remaining on this case. Probation is recommended to continue on probation and complete ADET within 30 days.
All right. And when was his conviction date?
July 18th, 2023.
Did he ever report?
I can give you an answer. Hold on. Wilcox. It looks like he has not reported at all.
At all?
No.
All right. And he has 254 days. So with the sheriff's options. Oh, okay. He's had other issues in 2023. And you said he was July 18th, 2023. Okay. Okay. Yes, sir. Mr. Haddad.
Your Honor, my client is 53 years of age, Judge. He's been in custody since January the 5th of this year on this probation warrant.
I'll definitely give him credit for the 14 days.
Judge, I understand the court's concern. And I don't know about his history. I did not look up. I know the court mentioned just a few minutes ago. There's still plenty of time left on probation for him to do what.
But he won't comply. He never complied in 2022. I'm really concerned about his history, but he won't comply. I mean, I might as well just keep him in jail to finish out 240 days, which would be 120 days in jail. That's 4 months, and then he's done with the case.
I mean, I understand the court's position, Judge. Nonetheless, I would still ask the court to give him another chance. It's something that he should have done. I'm not disputing that. I know he had entered the plea in July 18th of 2023. And within, 3 months, of course, of him not reporting, a warrant was issued. So there's a lot of time left on his probation to do what he was supposed to do. But I mean, other than that, I don't have a legal excuse for Mr. Wilcox, other than, sometimes it takes a couple weeks in custody to understand the court's seriousness when the sentence is issued to start with. Something they should have, I mean, he's old enough to know when he entered the plea that that he has to abide by probation, but he didn't. So that's where we're at, Judge. I would, I mean, if the court is inclined on not following the probation's recommendation, in light of the charges, I would ask the court to consider something less than the balance to revoke. I would just simply ask perhaps for revoking him for 60 days or 90 days with credit for the time that he's done. So we're gonna close out the case.
The sentence is to revoke 60 days, credit for time served, which is 14 days. He will serve out that additional time. After he's completed the remainder time on the 60 days, then he will report to probation, and he will continue to report to probation to complete the alcohol and drug evaluation and the anti-theft class. And will continue to report to probation until the remainder of the time is left. So which means that he has completed 14 days. The state will give him a credit for 28 days. Then he has 15, I think it's 16 days left at the jail.
That's correct, Judge. Thank you.
All right. Mr. Wilcox, as a result of your significant criminal record history, as well as your complete and blatant failure to comply with your sentence, the court is imposing that you serve out 60 days as a sentence for this probation violation. This will be marked as a probation violation. Once you've completed the time, you are required to report back to probation and continue to report once a month. Complete your alcohol and drug evaluation and your anti-theft shoplifting class within 90 days of being released. Do you understand? All right. If you do not report, please understand that, we suspend probation and you get to do this all over again.
Thank you, Judge.
Thank you.
Position number 7 on the probation revocation calendar.
Deputy, could you give me that number again? Was it 6 and 7?
Just 7.
Just 7. Okay. Is
No,
this the
7 and 8.
Just 7 and 8.
yes?
We've had 2 different calendars, Judge. Those
Okay.
last one.
This is Shamika Latwana Lee. Could you please raise your hand if you're Miss Lee? Just want to be sure. Thank you. All right. Miss Lee, you have a probation revocation matter in case 19 CR 6925C, in which you were convicted of one or more of the following offenses: obstruction of a law enforcement officer, disorderly conduct, giving false information to an officer, and simple battery, and contributing to the delinquency of a minor. Your probation revocation case is 24 PV 90, in which is alleged that you failed to comply with the terms of your sentence while you were on probation. You've been advised to remain silent, and your attorney is Mr. Haddad. Ms. Officer Allen, what's the basis for revocation in Ms. Lee's case?
Ms. Lee failed to pay court fines and surcharges in a total of $410, probation supervision fees in a total of $280, victim crime funds in a total of $63, failed to report as directed on February 28th, 2023 and May 22nd, 2023, failed to complete Operation 21. She has 72 days remaining on this case. Probation is recommended for time served, case closed.
What? Mr. Haddad, is your client willing to accept these terms?
She is, Judge. Thank you.
All right. This will be marked as a probation violation on a record, and the court will commute the remaining time of 72 days to time served, and that closes the case. Thank you.
Next, Your Honor, is going to be position number 11 on the probation. Courtroom 2.
All right. This is Ladarian Dwayne Young, convicted of simple battery family violence in case 18 CR 34G. This is a probation revocation matter. Mr. Haddad?
It is, Judge.
All right. Mr. Young, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. Officer Allison, what's the basis of the revocation?
Yes. Mr. Young failed to pay probation supervision fees in a total of $160, victim crime funds in a total of $36, failed to report as directed on February 1st, 2018, May 18, 2018, and July 27, 2018, failed to complete anger management course, did not complete ADT, and failed to appear to a prior revocation hearing on October 17, 2018, has 84 days remaining on this case. Probation is recommended to continue on probation and complete ADT within 30 days.
Where has he been, Mr. Haddad?
Your Honor, at the time that this happened in 2018, Judge, I believe the alleged victim was his stepfather, and my client relates to me at the time. There was a lot of tension, which led to, this criminal act. Shortly thereafter, Judge, and again, I don't have any legal excuse, but Mr. Young has turned things around. He should have, of course, reported. He didn't and follow through. It's ultimately his obligation. But he had been living with his grandmother, Judge, and ended up was gainfully employed at 2 different places. I've reached out to his mom yesterday, but did not get through. My client relates to me that things are I think, I don't want to say maturity, but I think he's in a much better place now. The last 3-4 years. Now, that does not negate the fact that he should have followed up with probation. But there's still a little bit of time left. He's 27 years of age, Judge. It relates to me that one of the jobs he has is a forklift operator that is still available for him. And I would just ask the court to continue him on probation. He's been in custody for 14 days, Judge. And it's an old case.
It is, with absolutely no activity on probation.
I guess the flip side, I guess, I don't have an accurate GCIC, but I can only assume that the good news is he's not been charged with anything. He's managed to stay out of trouble, which is great. But, and then I would like the court to take that into consideration as what an appropriate sentence should be in this case. And I would request the court to consider releasing him on time served and give him time to
I still don't have an answer to my question. Where has he been? It's been 5 years. Has he gotten a GED? Has he gotten a degree? Was he working? Was he in prison? What was it? You're asking me to let him back on probation for 5 years of not doing what the court asked him to do. So you're asking me to condone his complete disregard of being sentenced and not completing anything while he was supposed to have done on probation. Now, if this is the message you want me to send to this young man, I don't think it's going to resonate with him or resonate with me.
Your Honor,
I'm really curious. What has this young man done in the 5 years that justifies me releasing him back in the community instead of paying his price to society for this conviction and serving out the rest of the 84 days in jail?
To answer
the question buzzing in my head.
To answer the court's question is specifically, my client has been employed. He's been working as forklift at Mattress Firm, a warehouse. He also has been working as a cook at North River Tavern, Judge. He has been living with his grandmother. That's what he's been doing the last 4 years. He's been working. Now, that does not change the fact that it's ultimately his obligation to report to probation or follow through. He did not. He was arrested when his name was run, that's how the warrant popped up. You know, all I
Yeah.
can say is at least, at the very least, I mean, I understand he ignored the court's sentence by not
Completely.
reporting, but
Completely.
the other
I
side,
just don't get it.
I understand, Judge. I mean, I understand what the court's issues and concerns are, but I guess in as far as mitigating is the fact that he's not been in any kind of trouble. He's not been arrested on any charges. He has been gainfully employed and he's been living with family. So, I mean, that ought to, I think, in some ways count somewhat with the court's, you know, kind of weighing what's appropriate in this case. And he has spent 14 days in custody. And I think that's, you know, that's big for somebody who's not really been spent that much time in custody before.
Okay. 84 days is just about under 3 months. Mr. Young is going to continue on probation. His first report date is Monday, this coming Monday, before 3 p.m. He's to report every month. Within 30 days of being released, he's to complete an alcohol and drug evaluation and show proof of completion to the probation officer by his second probation visit. He's to complete 8 anger management classes, which means that as soon as he's released, he must enroll in an anger management program. And by his second visit, he must show proof that he has completed at least 2 classes. All right, and he is to continue to report. The minute probation finds out that he has not completed any of these things within the next 30 days, they are authorized to issue another warrant and have him serve out the rest of the time, day for day, in the Fulton County Jail.
Thank you, Judge.
Your Honor, can I say thank you? Your Honor, I just wanted to say I really, really do thank you, and I promise I'm not going to disrespect the court at all or your decision. Thank you very much.
All right, thank you so much for that, but proof is in the pudding. I need you to do it, not just say it. Thank you.
Thank you, Judge.
Your Honor, that concludes my probation matters. Can I be excused, please?
Let me, 1, 2, 3, 6, 7, 8, 9,
That's
10.
it on the probation.
Thank you, Officer Allison. I think Officer Norris got a great Christmas gift from you. That's why he completed probation today.
I greatly appreciate it. You guys
There
have a
you
good
go.
day.
All right. Is position number 14 available by any chance for Mr. Murphy?
Position number 14.
And that is Jartavius Johnson. Would that be
We have to
correct?
wait for the roving officer to get upstairs.
Okay, so that's jail court iPhone. Who do we have?
Yeah, we have position number 14 right here, Jartavius.
There you go.
Thank you.
Johnson, conflict.
All right, this is position 14, Jartavius Johnson, case number 23 CR 7084F. Mr. Jartavius Johnson, sorry, I gotta remind you of your rights. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Dennis Murphy III. Do you see your attorney on the... All right, are you done fidgeting with your clothes?
Hey, Mel.
Sit up straight. All right, do you see your attorney on the screen?
Hey, Mel.
All right, good. Mr. Murphy, is your client aware of the offense brought against him?
He is, Judge. I've
All
seen him
right.
now.
And
And
is
this-
that the
Yeah.
offense? Oh, so sorry, Mr. Murphy. What are we doing with your client's case today?
Judge, I'm going to ask for a reset for a week. He's being held on other charges. He's been in custody since July 5th. Now, this particular case is an incident at the jail involving a correctional, a deputy probably. And then he has the other charges, and I need to speak to his felony attorney. And I've tried to reach out to this man twice, and I've conveyed the client.
Do you know who is the attorney in this Superior Court matter?
I do, Judge. Just give me a sec right here.
Yeah, I just wanted to be sure you knew who it was, then I wouldn't have to look it up.
Yes, Judge, just a second here. I've reached out to him twice.
That's all right. If you don't have the name offhand, I just wanted to be sure you have it.
I do. Yes, Judge, I've got it now.
Okay.
His name
And
his
how
name is
far
Mark.
out would you like it reset?
1 week out. His felony attorney's Marcus Lee,
Okay.
and I reached out to him twice, and I haven't even been able to leave a message. But so eventually get his phone and get back to me. So if you can just reset it 1 week, Judge. Again, he's got other charges.
All right. Are you planning, well, let me know in 1 week whether you plan to file a waiver of arraignment or what, like the case arraigned at that time, or whether this is going to be a plea.
Yes,
Okay.
and I will do that, given that we have seen the state's offer. I've conveyed that to my client. It's essentially no offer. So perhaps a waiver will be forthcoming in a week, but hopefully somebody will reach out to me. Thank you, Judge. That's all I have.
All right. Thank you. Thank you, Mr. Johnson. We will see you on January 25th.
Your Honor, just to put this on the record, the defendant is currently not being held on this charge. And in fact,
Oh, yes, I know that. I know that.
so I just wanted to make sure that it was clear,
Yeah.
regardless of what he does on this, he's still being held on other charges.
Yeah, that was patently clear to me once going through his files. Thank you. All right, Miss Courtroom 2, who do we have now? Mr. Murphy, was that it for the SAP calendar?
It is, Judge. Thank
All
you
right,
again.
January 25th at 9 a.m. Your client's Mr. Johnson. All right. Where are we going to now? I have
ACDC.
all right. Mr. McLean, did you have a comment?
Yes, could I have Ms. Falk call 612-2392, please? Because I need to figure out whether there's an offer on Mr. Fletcher.
Okay. ACDC, who do we have, please?
Position 1 and 2.
Okay.
Ms. Brown is a negotiated plea.
All right. Thank you. This is a good morning, the folks at ACDC. My name is Judge Lal, and this is for all of you there seated before the Zoom panel. This is going to be a misdemeanor plea and arraignment calendar. So I'd like you to remember that when I address each of your cases, to remember that you have a right to remain silent. Anything you say in open court, like even this virtual court that's being recorded and live streamed, that all your comments can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one of our attorneys from the Public Defender's Office or Conflict Defense List will be representing you. So presently we have Brittany Brown, who's got a case 23 CR 624E, in which she had been accused of DUI under the influence of alcohol, less safe, failure to obey traffic signs, and possession of an open alcohol container from April 24th, 2022. Ms. Brown also has a bench warrant matter 24 FTA 59. Ms. Brown, your attorney is Mr. McLean, and I understand this is going to be a negotiated plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Falk, what's the recommendation for Ms. Brown?
Yes, Your Honor. The recommendation on the DUI is on count 1, 12 months, probation served 26 days, credit for time served 13 days. That is from January 6th of 2024. Balance would be probated, a $600 fine, 30 days of community service, as this is her second DUI risk reduction, 50 victim impact panel through MAD and ADET. On count 2, we are requesting a $265 fine concurrent to count 1. On count 3, a $265 fine concurrent to count 1. We are also in agreement to null pros position 1 on the acceptance of this plea. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
For the purposes of this plea, we do so stipulate.
All right. Mr. McLean, as your client is pleading guilty to a DUI offense, one of the other requirements is to surrender her license to the probation officer because her license will be suspended for a year.
I did advise her in the interview, Your Honor, that in addition to whatever 1-year suspension happened at the time, that there would be another.
Oh, it'll be suspended again.
Yes, it will. And she will deal with, as far as any possibility on second time DUI. I'm not very familiar with whether there's any possibility of a permit, but she'll be dealing with driver's services in Conyers, Georgia, with regard to information on any possibilities there, but I don't have any basis on which to offer hope.
Okay. Ms. Brown, and I'm so sorry, Mr. McLean, you did stipulate to the factual basis, venue, and ID, yes?
Yes, Your Honor.
Okay. Ms. Brown, are you still willing to move forward with this plea hearing?
Do I have permission to speak with my attorney before I continue?
All right. Please step aside and we'll take the next case. And Mr. McLean, I think she has a big question about the license suspension.
Probably. Your Honor, if the phone might be more convenient, or we could do a breakout, but the number would be 612-2392.
All right. ACDC, we can take another case up there.
Was the number 2392?
That's right.
Okay. We have position number 19.
All right. Is that your case too, Mr. McLean?
That is a not guilty bond request from Savannah Nutting.
Yes, Savannah, nothing.
Yes.
All right. Savannah Nutting is accused of reckless conduct and misdemeanor possession of marijuana less than 1 ounce. Case number 23CR8419G. Ms. Nutting, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. Ms. Falk, what is the state's announcement for this case?
Yes, Your Honor. We have been reaching out vigorously to the DA's office, but have not received a response yet. I followed up again this morning. I followed up about 2 or 3 times. But there has been a delay with receiving responses on several cases. This is one of them. So I am continuing to reach out and continuing to try to follow up to get a response. However, this is pretty clear on the record that the defendant at this point is a convicted felon in possession of a firearm. This case was based on the facts of this case are that on December 27th of 2023, Ms. Nutting admitted to being angry and mad and recklessly firing multiple rounds in the sky from her Glock 30 .45 caliber handgun in the parking lot of the apartment building, which did endanger the bodily safety of others. In our request to transfer, one of the things that we cited to was the fact that Ms. Nutting has a conviction currently from.
Oh, I'm familiar with the case. Thank you. But
Yes,
so you haven't received any response yet?
I have not.
Okay.
And at this point, we are asking that the bond remain as set. But it is not as though we have received a response of no, and quite frankly, because statutorily she is a convicted felon, and it is the state's opinion that the DA's office will have to accept this case based on the felony conviction.
All right. Mr. McLean, so this case, shall I arraign the case, or will you be filing a waiver of arraignment at the present time?
With my client's permission, I believe we can file a waiver of the arraignment, Your Honor. She simply is asking today, her mom is deceased recently, and her mom's friend named Sandra, along with her, with Miss Nutting's aunt, are going to be all over her on all these cases and help her out with certain needs. And she's requesting a signature bond so she can go to the hold. I believe it's a DeKalb probation that should be able to be handled. And then when she handles that hold, she'll be able to fully deal with this case. We heard what the state was saying, and if there's a conviction, there's a conviction. We're not arguing that, but if the court could give her a signature bond, she could scoot over there, handle that, jump back on this. But she does have family support. It's unfortunate that she's been through the family sadness. I don't know the cause of death, so I won't call it a tragedy, but it is is full of grief for her.
All right, Ms. Falk, there's a request to modify the bond.
Yes, Your Honor, and based on what we have presented, we are asking that the bond remain as set. Your Honor saw fit to set this at a $3,600 surety bond. Nothing has transpired over the last 3 weeks that would change that calculation in the state's opinion, by Your Honor. None of the Ayala factors have changed at all in reference to Ms. Nutting's actions and her criminal history.
And I do appreciate Ms. Nutting's situation. I'm not without sympathy, but a similarly situated person would possibly also get an opportunity to remorse. However, in Ms. Nutting's case, this is an individual who's been alleged to be in possession of a firearm, and not only alleged to be in possession, but alleged to discharging it while she is on probation in 2 separate felony matters. And Ms. Nutting, at some point, you have to be accountable for that. Your bond reflects the circumstances of your current case and the circumstances of your record. And I don't find any reason to modify it. If your family support comes through in terms of helping you to bond out, that would be great. But please keep in mind that you're not to have any firearms. You're not to be in possession of any firearms. And you're definitely to stay away from that apartment complex.
Right.
You have a right to remain silent. Anything you choose to say can and will be used against you.
Yes, ma'am. I just, it's not the issue of paying the bond. The bond companies are telling me because my warrant in DeKalb is without hold, I cannot pay the bond to go to DeKalb.
So in that case, you would have to come up with a cash bond.
Okay.
Thank you. All right, I'm sorry, Ms. Nutting, your attorney is asking for your permission of whether you want to enter a not guilty plea in this case.
Yes.
All right, Mr. McLean, if you will file a waiver of arraignment.
We will do so. We actually have luckily we have the paper forms with us today, and I have some white out to cross out the name of the person who used the last form.
All right, if that works, that's fine. But please confer with her in terms of the consequences of filing a waiver of arraignment, because I don't know if you.
She knows it's a not guilty plea, right? Yes.
All right, thank you.
She will attend court.
Position number 19 is further notice for trial. The bond modification is denied. Thank you. May I take the next lady in ACDC?
Is that Kristen Davis?
No, it's
All right,
That's mine.
Kristen Collier.
Kristen Collier was released.
Kristen Collier was released?
What's your name, please?
That's number 6. Okay, thank you.
Veronica
Smith.
All right.
Position number 31 and 33. 31 through 33.
All right.
Since midnight. That's bad. That is bad.
This is State versus Veronica Smith. Ms. Smith, my name is Judge Lal. You've been advised of your right to remain silent, and your attorney is Mr. Jawan Haddad. The 3 cases that are listed on our calendar with respect to you are as follows. First one is 21 CR 2992F, in which you were accused of criminal trespass from June 14, 2020 at the at 1940 Fisher Road in Southeast Atlanta. The second case is 24 CR 82F, in which you were accused of simple battery with regards to a Lee Brooks at 355 Peachtree Street, Northeast Atlanta in Fulton County. You've also got a bench warrant, 24 FTA 47, in which you've got a bench warrant for failure to appear on November 30th, 2023. With respect to all these three cases, Mr. Haddad, how are we proceeding?
Your Honor, I think I've indicated by an email that she's pleading not guilty, Judge. We just want to be heard as far as a bond reduction in this particular case.
All right. Would you like me to arraign the case, and do you waive a reading of the accusation?
We waive, Judge.
All right. Ms. Smith, as I've indicated, these are the cases in which have been accused and pending against you. With regards to the misdemeanor offenses of criminal trespass and simple battery, upon your entry of a not guilty to these offenses, the case will be scheduled for trial. At the time of the trial, the prosecution would have the complete burden to prove the charges against you beyond a reasonable doubt. If the prosecution succeeds and overcomes your legal presumption of innocence, then you could be convicted of one or more of these offenses and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead to the charge of criminal trespass and to the other charge of simple battery?
Well, my understanding, can I speak to my lawyer again? Because to my understanding, I need to speak to him. He didn't explain that to me yesterday.
All right. Okay, ACDC, it looks like 2 phone calls have to be made from your location to the jail.
Ms. Brown already spoken with the.
Oh, okay. All right. Miss Veronica Smith will have to speak to Mr. Haddad. Miss Brown?
Yes, Your Honor.
All right. Would you still like to move forward with your plea?
Your Honor, can you give me about 20 seconds just so I can let Mr. McLean know I ended up talking to the client, Judge, because he was in front of the court. So I just
Okay. You saw this, Brown?
Yeah.
So,
Just 1 second, Miss Brown.
Yes, ma'am.
Jail court iPhone, while we're waiting, who will we have there?
I'm sorry. We have position number, where we at? I think 5. Hold on. Yeah, position number 5.
Okay, that would be Javaris Chastain. All right. And officer at jail court iPhone, do you have any other cases there?
No, he's the last one on this floor. We have to go down to another floor and
Okay.
get to.
Mr. Chastain is represented by conflict counsel. I do not have conflict counsel. Miss Champion or excuse me, Miss Grace, do you have any updates on whether conflict counsel will appear for position 5?
Yes, Judge, I spoke with Miss McLeod. She's in Gwinnett County. She said she should be done by 11, and she will contact me back to see if we're still on and she can jump on.
All right. Jail court iPhone, Mr. Chastain's attorney isn't available till 11 a.m.
Okay, so we'll come back.
Okay, thank you.
You're welcome.
Okay, Mr. McLean, we are going back to position 1 and 2.
Mr. Haddad has updated me on Ms. Brown's wishes. Your Honor, we wish to change the guilty plea on the DUI to a not guilty, and she wishes to explain to the court that she was not at fault for missing her court date. Therefore, I don't know that I got to the point last night of explaining that if that the court is not in a position, and I doubt the state is in a position to grant a request for dismissal here on a SAP, but we certainly are in a position to ask for a signature bond on the FTA itself, which would be giving her the same benefit as that other request for the moment.
She's got a bond forfeiture hearing before Judge Morrison on January 24th at 2 p.m. in courtroom 2F. This case is assigned to the division judge. I would let Judge Morrison address her bond modification.
I really would love it if Ms. Brown would call me on the phone one more time, Your Honor.
All right. So right now, are we arraigning the case then?
If I could talk to her one more time, Your Honor, just. before we
Okay,
do that,
thank you.
I'll ask.
There are no phones available right now.
I know.
All right.
2392 will be available in just a few minutes.
All right.
And I
ACDC,
have no attorney
please
available.
hold. All right. Court Officer Norris, we can take the next client for Mr. McLean.
We can go to position number 9, Mr. Jimmy Davis.
And Mr. McLean, this is still a case to be arraigned?
I believe this is not guilty, but Your Honor, if it were 30 days, then let's see. All right. Let me flip to that, Your Honor, for just a second. That's page 2. Actually, the calendar came over with no booking numbers and no pagination, so let me flip to that.
Okay, do you need a booking number?
No, Your Honor, we got on the computer and looked it all up.
Okay,
So, it's just one of those bureaucratic things. If the state were to think of 30 days instead of that 90, that would equal time served. But if the state is not inclined to do that, we would try to persuade them. As it is now, this would be a 30-day extra sentence because the 90 divided in half would be 45 minus 15. It would equal 30 extra days. And at this point, he can't take that. It is a simple battery family violence, Your Honor, from 2024, and that's this year. But we would seek to do that as a counter offer. If we could do a negotiated plea and any other additional thing, FDIP is understood. The 40 hours community service could go up.
I don't know whether you're thinking out loud, Mr. McLean, or whether you were asking me a question.
I'm negotiating out loud, Your Honor.
But at this juncture, is your client wanting to do a non-negotiated plea, or does he want his case arraigned?
He'd love to go home. Ms. Falk, what saith the state?
He's got a bond of $2,000 as issued on January 5th, and that was based on his criminal history record and the circumstances of the case. And
Right.
that's the bond is going to stay.
And
So-
just to clear this up for the defense, the state, based on his history and based on the facts of this case, has no intention of revising this recommendation.
I think we need to go with the not guilty and try to make that bond.
All right, is that what Mr. Jimmy Davis would like to do?
Mr. Davis, is that your understanding of what we need to do? But they're not gonna go with third. No. Non-negotiated plea is not what we're discussing. We're discussing a counter offer. Okay. So you're gonna stick with the not guilty?
I'm sorry, Mr. McLean,
We are
hot,
sticking
so
with
I
that.
didn't, I know you have a hot mic, so your discussion with your client is being broadcasted.
I understand. We're gonna stick with that not guilty, Your Honor.
All right, would you like to file a waiver of arraignment? Would you like me to arraign the case and waive a reading of the accusation?
We can waive the reading of the accusation. Actually, we could file a written waiver of presence and everything else. Your Honor, was this one where the bond was moot or whether I'd indicated a bond request?
This is the one where position number 9, you just said not guilty.
Right. And if I might, Your Honor, let me lean over and take a look at his booking sheet. On his booking sheet, what else is holding him? I believe I've got that right here.
Go ahead.
Not yet. This is the only thing holding him in jail, so if the $2,000 were addressed as a reduction, even cutting that in half would help him tremendously in getting ready for trial, Your Honor.
Yes, I understand, Mr. McLean, but I have no reason to modify that decision. Anything else, Mr. McLean, or shall I accept that you will file a waiver of arraignment and I'll further notice the case to trial?
We will do that, Your Honor. I'm going to file the waiver. Thank you.
All right.
I'm going to file a waiver. We don't know when the next court date is. This court is not setting court dates for the trial.
All right, Mr. Haddad, have you had a chance to confer with Ms. Veronica Smith? Otherwise, I'll place you in a breakout.
Judge, I did, but I have an update. If I can, I apologize if I can speak to Ms. Smith. The state was gracious enough to come down on the recommendation.
I understand your laptop is on, so I didn't, and you're connected to Zoom. So if you want to go to your laptop, I can place that and the jail court in a breakout.
That'd be great. Thank you, Judge.
All right. Miss ACDC, you're going to see a message on the screen from the host to join a breakout session, and hopefully Mr. Haddad will be there too.
That leaves me with no attorneys.
All right. Mr. McLean, can we take your next case?
Yes, Your Honor. Who's the next case? Which case is next?
Officer Norris, whoever.
I have you on. We're gonna go to position number 17, Mr. Millender.
All right. Rodriguez Millender, excuse me.
And Your Honor, it looks like it's missing a vowel, but it's actually not. It is actually spelled just like it's on the calendar.
Okay. Mr. Rodriguez Millender, and you're the gentleman's Millender?
It's Millender, but
It's spelled that way.
that's the way they spell it.
Okay. Case 24CR96Y, accused of fleeing or attempting to elude an officer and reckless driving and possession and use of drug-related objects from January 4th, 2024. Mr. Milder, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Mr. McLean, shall I arraign the case?
No, Your Honor, we can file a waiver as to that. He is here while the state is seeking to upgrade it to a felony level, fleeing, eluding. He would like to state that he had 5 or 6 years ago, he had a DV case. He had a DUI about 8 or 10 years ago, which was reduced to a reckless driving. So it's not a DUI conviction. And with those two statements, he's a graduate of McEachern High School in Powder Springs, which I believe is Cobb County, Georgia. And with that statement, he would like to ask the court to lower his bond substantially, perhaps even a signature bond, even while this proceeding.
All right. Let me see. Pretrial. Ms. Tyson, good morning with pretrial.
Good morning, Anna.
Good morning. We have position number 17, Mr. Rodriguez. Last name is Millender, spelled Milnder. And he's got a hold as well in a different jurisdiction, which is Cobb County. Any priors, please?
Yes. He has a Douglas County DUI conviction from 2017. He had a felony case out of Douglas County. Let's see, for misdemeanor willful obstruction, criminal trespass, family violence, possession of Schedule II controlled substance. That's 2 counts, and 1 count of simple assault, family violence. That's from 2020. He received first offender treatment on that case, and he did successfully complete the conditions on that case. The case was sealed, let's see, December 7th of 2020. Does have another felony conviction out of Fulton County for possession of methamphetamine. Let's see, disposition date on that is August 30th of 2022. He received first offender treatment on that case as well. He has 3 years probation on that case. He has 2 additional violations of probation, and his last arrest was in Marietta, June 7th of 2023, and that's for battery. No dispositions listed on the GCIC, and the hold is out of Marietta. It looks like for a failure to appear. That warrant was signed October 30th, 2023.
All right.
Nothing to add, Your Honor.
And the 2017 Douglas County DUI that you mentioned, does that show the reckless reduction?
No, no. I believe that I did see there's another one, but no, this one doesn't. It just says DUI. No, nothing else is listed from 2017. Let's see.
Irrespective of that, given the nature of the his history and having refreshed my memory on the allegations of the warrant, the bond modification is denied.
And I'll file that waiver on the actual charge, Your Honor.
All right, and this case is further noticed for trial. And again, Ms. Falk, right now the case will be arraigned pursuant to the waiver. If the case is accepted by the DA's office as a felony charge, then please submit the appropriate order. Thank you.
Yes, Your Honor.
Okay, I'll sign the waiver for you. It just means that you know what the accusation says. That's all.
Officer Norris,
Your Honor, we're gonna have to do Cobb County and Marietta Annex because their transport officer is waiting. So I'm gonna start with Mr. Danny South, and that's position number 34.
all right. Mr. Haddad would have to return back, okay?
And Your Honor, that is ready for a negotiated plea, Judge.
All right, sir, thank you. We have State versus Danny South, case number 24CR 242Y. Mr. South is accused of giving false information to an officer, and a second count of giving false name or address or birth date to a law enforcement officer. It looks like 2 counts of giving false information. This stems from a October 19th, 2023 incident in Fulton County, Georgia. Mr. South, you've been advised of your right to remain silent, and your attorney is Mr. Jawan Haddad. This is going to be a negotiated plea hearing. May I place you under oath? Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
I beg your pardon?
Yes, Your Honor.
Thank you. Mr. Pierre Thomas, what's the recommendation for Mr. South?
The recommendation from the state is that for the defendant to complete, basically, this is a time served offer where the defendant will serve 178 days in custody, credit for the 89 days that he's already served in custody. Looks like he was booked in on October 20th, 2023. And that is as to count 1. As to count 2, that will merge with count 1.
Mr. Haddad, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
We stipulate and my client accepts these terms, Judge.
All right. Mr. South, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor. Thank
Are
you.
you okay? And are you satisfied with your attorney?
Completely, Your Honor.
If you decide to accept this, if you decide to enter this guilty plea to this charge of giving false information to an officer, You would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to go back to court, to face your accuser, to challenge the evidence brought against you, to present any defenses if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of giving false information to an officer?
Guilty.
Your sentence is 12 months to serve 182 days, credit for time served 89 days, balance suspended. The count 2 will merge with count 1, and that closes the case out. Thank you.
Thank you, Judge.
Thank you.
Your Honor, it's gonna be position number 20 and 21, Mr. Odom, Ramon Odom.
All right. Okay.
Mr. Odom, I believe, is the negotiated plea, Your Honor.
This is position 20 and 21. Okay. On position 20, Mr. Ramon Odom, excuse me, is case number is 23 CR 3957E, in which he is accused of willful obstruction of an officer and criminal trespass. The second case is a bench warrant 24 FTA 55, in which a bench warrant was issued from a January 4th, 2024 incident. Mr. Odom, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a negotiated plea, so may I place you under oath, please? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Pierre Thomas, what are the terms for position 20?
One moment, Your Honor. I'm having technical difficulties. Your Honor, the offer from the state is for the defendant to serve 12 months on probation. That is to be concurrent with count 2, and to pay a $300 fine. As it relates to count 1, as it relates to count 2, the defendant is to serve 12 months on probation, to serve 34 days in custody, credit for the 17 days that he's already served in custody, which appears to be that he was booked in on June 22nd, 2023, and released on June 23rd, 2023, and then also rearrested or rebooked on January 4th, 2024, for the balance to be suspended for him to stay away from the MARTA station located at 30 Alabama Street in Atlanta, Georgia.
At 5 points?
Yes,
Yeah, that is a 5 points location.
that's 5 Point Station.
All right, so you want him to pay a $300 fine for count 2, and he'll be on probation until that's paid off?
It's actually a $300 fine associated with count 1. It's basically statutory.
All right, but you don't have that for count 1, and you've got balance suspended, so.
No, in the offer, Mr. Pierre Thomas is correct. It's count 1 would be the $300 fine, but count 2 would be the suspended balance. So, Your Honor, what we're going to ask the court is that as soon as he pays that $300, which he believes he can do within 2 or 3 weeks, if Your Honor could let it go to non-reporting or termination, that way he would pay probation $1 $49 fee and then be done.
Okay, so what I'm going to do is count 1 is going to be a $300 fine, concurrent to count 2, and count 2 is going to be balance probated to pay the fine, and as soon as the fine is paid off, I'll terminate probation.
Excellent.
Is that acceptable?
It is, Your Honor. Thank you.
Mr. Pierre Thomas, any objection to that?
No objection, Your Honor.
And
I mean, if it could transition to suspended, that'd be ideal.
I can only suspend it, but there's no guarantee about the fine, so.
Saying if it transitions after he pays the fine, if it transitions to suspended.
Oh,
as
that-
as
yeah.
opposed to completely terminating it.
I'll do that. That's no problem also. Okay. All right. It's actually the same impact. Is there a reason why we're going with balance suspended? It's just for the disposition when we fill out the sheets. It just makes it easier.
So if the balance is suspended, he still has to adhere to the stay away and things of the such. But if the probation is terminated, then
I'll make it non-reporting then.
yes, non-reporting is
I think that's what you're asking for.
yes.
Okay. Understand. You want compliance with the stay away.
So,
Okay.
He and I discussed fully staying away from 5 Point Station, so it's gonna be tricky, but he can, we talked about ways of doing that.
Okay. So in that case, Mr. McLean, do you stipulate to the factual basis, venue, and ID?
For the purpose of the plea, we do.
All right. I just lost my position on the calendar. Could you tell me what position number that was again? I've lost.
this,
Oh,
20,
I got it. Sorry, Mr. Odom, yeah, oh my God. Okay, sorry about that. My pages were all wanko. Mr. Odom, have you consumed any medicine or alcohol recently?
No,
And have you understood the proceedings so far?
yes,
So I'm impressed because there was a lot of back and forth on that. But are you satisfied with your attorney?
yes,
And are you entering a guilty plea to these charges freely, willingly, and knowingly?
yes,
And has your attorney explained to you that you cannot return to the 5 Points MARTA station for at least 11 months?
yes,
All right. If you decide to enter a guilty plea to these 2 charges, you would have to give up your constitutional right to a trial. You will not be able to go back to court, have a trial in front of a judge or a jury, to be able to confront your accuser, challenge the evidence that will be brought before you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to 1 count of willful obstruction of an officer and criminal trespass?
guilty,
Your sentence for the willful obstruction is going to be a $300 fine concurrent to count 2. On count 2, it's going to be 12 months to serve 34 days, credit for time served 17 days. So your jail time is concluded for criminal trespass, but you'll be placed on probation. Once you're released from all holds, you will have to report to the Fulton County Probation Office at 132 Mitchell Street in downtown Atlanta. You'll report to probation in order to pay off the $300 fine. Once your fine is paid off, your probation will be non-reporting. At all times, you are to stay away from the MARTA station located at 5 Points, which is 30 Alabama Street in Atlanta, Georgia. You can continue to use MARTA as long as there's no active suspension against you, but you cannot drop off or get transportation at the 5 Points MARTA station. You cannot be anywhere at that particular station. If you're in a train or a bus, you can go through that station, but you cannot stop. Do you understand?
yes.
All right. Thank you.
Done.
Okay, I believe that Ms. Brown may be able to dial me on 2392 now.
All right.
We have
ACDC.
position 27 and 28, Your Honor. This is gonna
Okay.
be Mr. Pope.
All right.
27 and 28.
By the way, ACDC, what did Ms. Brown want to let us know?
She's gonna dial now.
Ms. Brown? Okay, thank you. Position 27 and 28 involves Kevon Dontres Pope. Mr. Pope, you are accused in position 28, your case number is 23 CR 6910J of criminal trespass causing damage to property from November 4th, 2023. You have a bench warrant from December 14th, 2023, case number 24 FTA 56. With regards to these cases, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. Mr. Haddad, is this going to be a plea?
Yeah, it is to negotiate plea, Judge.
All right. Mr. Pope, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
I beg pardon?
Yes.
Thank you. Mr. Pierre Thomas, what's the recommendation for position 28?
Your Honor, the recommendation for position 28 is for the defendant to serve 12 months on probation, to serve 42 days in custody, credit for the 21 days, I'm sorry, that he's already served. Looks like he was booked in on November 4th, 2023 and released on November 9th, 2023, and then rearrested on the FTA on January 4th, 2024, for the balance to be probated, for him to stay away from the 174 Howard Street Northwest Apartment B, located in Atlanta, Georgia, and Fulton County, Georgia, for him to have no further contact with Wykesha, Wykesha, Carson, Carson, and for restitution to be open for 30 days. I do believe that we have been able to get in contact. I'm sorry. Yeah, I do believe that we have been able to get in contact with the victim. I don't believe that she'd be on today, but if we could sound for her in accordance with Marcy's law, that'd be greatly appreciated. She stated that we made her aware of what the plea offer was. She stated that she is okay with that. And so if we could sound for her at this time, just to ensure that she's not on today, that'd be greatly appreciated, Your Honor. And if we could have the defendant stipulate to factual bases, venue, and ID.
Wykesha Carson?
You don't play with her, I do.
All right. Mr. Haddad, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
We do, Judge.
All right. Mr. Pope, have you consumed any medicine or alcohol?
No.
And have you understood the proceedings?
Yes.
Is anyone forcing you to take this plea offer today?
No. Yeah, that's a.
Please
No.
repeat. Is anyone forcing you to take this offer today?
No.
And are you satisfied with your attorney?
Yes.
Mr. Pope, if you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial. You would have to give up your right to go back to court and face your accuser, challenge the evidence brought before you, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of criminal trespass causing damage to property?
Guilty.
Your sentence is 12 months to serve 42 days, credit for time served 21 days. Your jail time is concluded. Once you're released from any holds that are presently against you, you will have to report to probation at 132 Mitchell Street in downtown Atlanta at the first available business day. While you're on probation, you have to stay away from 174 Howard Street in Northwest Atlanta, not just apartment B, but the entire complex. Do you understand?
Yes, yeah, let's go down.
And you're also to have no contact with Wykesha Carson. You're not to be within 200 yards of her. You're not to communicate with her in any direct or indirect form, not even through a third party, through mail, email, phone, computers, or even on social media. The case will remain open for 30 days for the state to schedule the matter if restitution is still going to be pursued. Thank you.
Thank you, Judge.
Next is gonna be position number 39, Mr. Antonio Willis.
This is State versus Antonio Willis, case number 23 CR 8385E. Mr. Willis has been accused of pointing or aiming a pistol at another. These are two separate counts with regards to this case for the same offense. Mr. Willis, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. Mr. Haddad, this is going to be a waiver of arraignment. Will you be filing a waiver, or shall I arraign the case?
No, Judge, I can file the waiver, Judge.
Okay.
Just gonna put on the record that he's pleading not guilty and requesting a jury trial, that may be.
All right. And I think that was the only thing you requested in this matter. So the case will be further noticed for trial on these two misdemeanor charges. Anything else, sir?
No, Judge, thank you.
All right, thank you.
Next one is gonna be position number 25, Mr. Permenta.
Good morning, Your Honor.
Morning. Mr. Daniel Permenter is case 22 CR 00703E, cited for giving false information to a law enforcement officer, 2 separate counts on that charge. He's got a bench warrant from January 5th, 2024, case 24 FTA 58. This is going to be a negotiated plea, I believe. Yes. And Mr. Permenter, you've been advised of your right to remain silent. Your attorney is Mr. Haddad. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Pierre Thomas, what's the recommendation?
Your Honor, the recommendation from the state is on count 1 for the defendant to serve 12 months on probation, to serve 50 days in custody, credit for the 25 days that he's already served. It appears that he was booked in on February 13, 2022 and released on February 23rd, 2022, and then also rearrested on January 5th, 2024, for that balance to be suspended. And then also on count 2, that is to merge with count 1.
Yeah. It reminds me.
All right. Mr. Haddad, do you stipulate to the factual basis, venue, and ID for 1 count of giving false information to an officer?
We do, Judge.
Mr. Permenter, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with the legal services you've received?
Yes, Your Honor.
Is anyone forcing you or inducing you to plead guilty today?
No, Your Honor.
And it has been explained to you that you would lose your opportunity to go back to court to face your accuser in a trial before a judge or a jury, to be able to present any defenses or mitigating factors if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
I understand. Yes, Your Honor.
Yeah, you understand, but are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of giving false information to an officer?
Yes.
Your sentence is 12 months to serve 50 days, credit for time served 25 days, balance suspended. Count 2 will merge. Thank you.
I'm gonna give a call, okay?
Next is gonna be position number 38, Ricky Williams.
Excuse me.
Position number 38, Judge.
Yeah, sorry, it's just checking my cheat sheet on position 38 is 24 CR 87G. Ricky Williams is accused of willful obstruction of an officer, possession and use of drug-related objects, and a PI charge from January 3rd, 2024. We will waive sounding on count 3. Mr. Williams, you've been advised of your right to remain silent, and your attorney is going to be Mr. Haddad. This is going to be a negotiated plea hearing. Mr. Williams, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Please speak louder. What did you say?
Yeah.
Okay. Mr. Pierre Thomas, what is the plea recommendation for counts 1, 2, and 3, without reference to sounding out count 3?
Your Honor, the recommendation for count 1 is for the defendant to serve 12 months on probation, to serve 45 days in custody, credit for the 15 days that he's already served. It appears that he was booked in on January 4th, 2024, and for that balance to be probated. As it relates to count 2, for the defendant to serve 12 months on probation, that is to be concurrent with count 1. And as it relates to count 3, for the defendant to serve 12 months on probation, that is to be concurrent with count 1 as well. In addition, he is to stay away from 2, 3, 32 Forsyth Street Southwest, Atlanta, Georgia, and Fulton County, Georgia. That is the Greyhound Bus Depot. So in totality, that would be 12 months probation to serve 45 days in custody, credit for the 15 days that he's already served, for the balance to be probated and for him to stay away from that Greyhound Bus Depot. In addition to that, if we would like for him to complete an SDET as
DET?
well.
So y'all are still requiring that?
Yes.
Okay. Mr. Haddad, are those the terms to which you have negotiated and your client has accepted?
Yes, Judge.
All right, and do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Williams, have you consumed any medicine or alcohol recently?
Oh, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And have you understood that you're required to stay away from the Greyhound bus station? And
Yes,
you're
ma'am.
also required to be on probation to complete certain conditions.
Okay.
I'm sorry, I didn't understand that.
Yes, ma'am.
Okay. If you decide to enter a guilty plea to these 3 charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to go back to court and confront your accuser, challenge the evidence brought against you, including the witnesses, be able to present any defenses or any mitigating factors if you choose to do so, and have the prosecution try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you entering a guilty plea freely, willingly, and knowingly?
That's asking, if you're entering a plea freely, this is what you want to do, plead guilty.
Yeah.
You need to speak up so she can hear you.
Yeah.
How do you plead to 1 count of willful obstruction of an officer, possession and use of a drug-related object, and to the 3rd misdemeanor offense that is identified as PI?
Guilty.
Are you familiar with the 3rd offense?
Yes.
He is, Judge.
Okay. And again, how do you plead? I'm sorry, I missed it.
Guilty.
On count 1, the willful obstruction, the sentence is 12 months to serve 45 days, credit for time served 15 days. And after he's served out the additional jail time, he will be reporting to probation if he has no other holds. If he has other holds, then he would have to report to probation on the first available business day, immediately upon his release. On count 2, and while he's on count 2, it will be 12 months probation concurrent with count 1. And count 3, it will be 12 months probation concurrent with count 1. And with regards to count 3, he's to stay away from the Greyhound bus station at 232 Forsyth Street in Southwest Atlanta. If he returns to that location, he'll be arrested for criminal trespass and also would have violated the terms of his probation. While he's on probation, he will also complete a program that we will refer to as a SD evaluation and treatment. If once he's completed the evaluation and if treatment is required, he must submit to that treatment at his expense. Thank you.
Thank you, Judge.
Position number 31 through 33, Veronica Smith.
Mr. Haddad, what would your client like to do in terms of entering a not guilty plea?
So, Your Honor, she's gonna enter a guilty plea on position number 31. So that's gonna be a guilty plea, negotiated plea on number 31. On number 32, we're gonna enter a plea of not guilty, but I still wish to be heard briefly on bond, Judge.
All right. And that would keep her bench warrant case alive and active as well.
Up until my argument, Judge, if at all possible, but yes.
Okay, all right. So with regards to position 32, case 24 CR 82F, Miss Veronica Smith, who has been advised of her rights In that particular case, on position 32, she's accused of simple battery from January 2nd, 2024 in Fulton County, Georgia. Do you waive a reading of the accusation?
We do, Judge, and I'll file the appropriate paperwork as far as that case.
Or are
Judge.
you going to file a waiver of arraignment?
Yes, Judge.
Okay, so on position 32, a waiver of arraignment is going to be filed. And that leaves the issue of her bond with respect to position 32. And presently, she's got a bench warrant in which she failed to appear in court on November 30th, 2023. But she was then subsequently arrested for the January 2nd, 2024 offense. Right, so on the simple battery, she had a first appearance and the bond was set for $1,000 good bond and no contact with Lee Brooks. Yes, Mr. Haddad, what's the request for modification based on?
Your Honor, I would just simply mention to the court that my client is 51 years of age. She'll be residing with her daughter in the city of Atlanta, Judge, Oakland City Drive. I have the actual address. She reported to me this morning that she's been diagnosed with cancer. She's been a housekeeper in the past. She's had, unfortunately, involved in a car accident in March of 2023. So she's unable to work right now. She's got very limited income, pending SSI, and I'll just ask the court to consider a signature bond. I understand the allegations that she missed court on the 30th of November. I talked to her about it. She said that she did not purposely miss court. She did not receive notice. That's all I have to offer, Judge.
All right. Mr. Pierre Thomas, any argument with regard to the bond modification request?
So first, I'd like to say that the bond is currently set, which I do believe, as you stated, was $1,000 surety, is extremely reasonable, as she has the two open cases. One of the open cases is for armed robbery in Fulton 22 SC 181792. She also has the open criminal trespass case from 2020. She also, in addition to that, she has a recent simple battery conviction out of Fulton in 2019. She also has another 2018 simple battery arrest out of Fulton. She has an affray arrest out of what I believe is Fulton. It states MARTA. And so we believe that is, as it currently is set, is reasonable. I can give you some facts of the case if Your Honor.
I'm familiar. Thank you.
Okay.
All right. Mr. Haddad, I believe this information was also addressed at the first appearance, and under the totality of circumstances, the bond was set at $1,000. Ms. Smith has a significant history of violence, and if she does have family support, I hope they will help her out with the bond issue, as well as helping her with to address these other open cases. Thank you.
Thank you, Judge.
Now, going on to position 31. Are you still moving forward with the negotiated plea?
We are, Judge.
All right. Veronica Smith in position 31 is accused of criminal trespass from June 14th, 2020. Ms. Smith, you've been advised of your right to remain silent and your right to an attorney. And if you please raise your right hand for purposes of the plea. Do you solemnly, please unmute ACDC? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. You were accused of criminal trespass from June 14, 2020, and the recommended plea, recommended terms of the plea are, Mr. Pierre Thomas?
Your Honor, the recommended terms of the plea would be that the defendant serve 12 months on probation, serve 64 days in custody, credit for the 32 days that she's already served. It appears she was booked in several times and released several times. For the balance to be suspended, for her to stay away from the 1940 Fisher Road Southeast Apartment 69A, Atlanta, Georgia, here in Fulton County, Georgia location, for her to have no further contact with Kennedy Cook, and that is all, Your Honor.
Okay.
And if you could sound for Ms. Cook, as I do believe that they are on today. I think it's a Mr. I do believe they are on today.
All right. Kennedy Cook, if you're present, please unmute and start your audio. No. Mr. Haddad, does your client accept these terms? And of course, as part of the, if there is a successful disposition of this plea, then the bench warrant matter will also be null prost.
Yes, Judge, we're stipulated as far as venue, identification and facts.
All right. Ms. Smith, have you consumed any medicine or alcohol recently?
No.
And have you understood the proceedings so far with regards to your criminal trespass case from 2020?
Yes.
And is anyone forcing you or inducing you to take this guilty offer today, to
No.
enter a guilty plea today?
No.
Are you satisfied with your attorney?
Yes.
And has it been explained to you that if you plead guilty, you would have to give up your constitutional right to a trial with regards to this case?
Yes.
You'll not be able to have your day in court to confront your accuser, to challenge the evidence brought against you, to be able to present any mitigating factors or defenses, and to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of criminal trespass?
Plead guilty.
Your sentence is 12 months to serve for 64 days, credit for time served 34 days, balance suspended. You are not to return to 1940 Fisher Road in Southeast Atlanta, and that would be the entire complex, not just Unit 68. You're also to have no contact with Kennedy Cook. You're to stay 200 yards away from this person, not communicate with this person indirectly or indirectly through mail, email, phone, or even on social media. This case will remain open for 30 days to address any restitution issues. As you are currently on bond in a separate case, you will, for as long as this case is concerned, you have completed all obligations. The bench warrant matter on position 33 will be null prost. Thank you.
Thank you, Judge.
So that means my bail. What's my bail? $50,000.
Your Honor, can we go to the add-on calendar and do position 1 and 2, Mr. Fletcher, Joshua Fletcher?
I'm gonna have that.
Let me just find out about Miss Brown. ACDC, what is Miss Brown doing with regards to her plea?
Oh, Your Honor, I can answer that.
Go ahead.
We are doing a guilty plea on the DUI.
Okay. All right, going on to Mr. Fletcher. This is state purpose add-on. Thank you. I don't think I printed that. Okay. This is State versus Joshua Earl Fletcher. Position 2 on the add-on calendar is 20 CR 5343C. And he's got a bench warrant matter as well, 24 FTA 40. On the position 2, Mr. Fletcher was accused of simple assault, family violence, simple battery, family violence, and hindering a person from making an emergency phone call from October 27, 2020. Mr. Fletcher's case, Mr. Fletcher, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. This is going to be a negotiated plea, Mr. McLean?
It is.
All right. Ms. Volt, what is the recommendation for Mr. Fletcher?
Your Honor, so there is one thing that we are still trying to hammer out, and while I'm communicating the recommendation, I can communicate that as well. So the recommendation was 12 months to serve 30 days. That is going to be from October 30th, 2020 to November 2nd of 2020, and then from December 28th of 2023 until today. So, excuse me, that would be serve 52 days. and then he would receive credit for time served for 26 days. The balance would be probated. We're also asking for a family violence intervention program, 40 hours of community service. We initially were asking for no further contact based on the bond restriction that was given to him when he first appeared on this case in 2020 to have no further contact with Miss, I believe her name is Kiaya, Kiaya White. I did speak to PD McLean. He indicated that they are living together. He did give me a phone number. Actually, I have an update to my update. So we have reached out to Miss White. When we initially called, it went straight to voicemail, but she has spoken to our victim advocate, and she does want no further violent contact as they do live together. So that's all we were trying to confirm before we could make that recommendation.
All right. And Mr. McLean, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
For the purposes of today's plea, we certainly do stipulate, and that is the understanding we have of the offer.
Right. Mr. Fletcher, have you consumed any medicine or alcohol recently?
No, ma'am.
All right. Oh, I'm so sorry. I don't think I placed you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right. So that was a no to medicine and alcohol. And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes.
And is anyone forcing you or inducing you to plead guilty today?
No.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial before a judge or a jury. You will not have the opportunity to go back to court, confront your accuser, challenge the witnesses and the evidence brought before you, have the state try to prove the charges against you beyond a reasonable doubt, and also give up your opportunity to present any defenses or mitigating factors if you choose to do so. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the 3 charges brought against you?
Yes.
Your sentence is going to be on I think it was a simple battery. It was a global offer for all 3 charges, Ms. Fall? Okay, so with regards to all 3 charges, this will be a concurrent sentence. It's 12 months to serve 52 days, credit for time served 26 days, balance probated. For you, while on probation, you will complete a domestic violence intervention program, and that is a 24-week program. You must begin those classes within 60 days of being released. While you're on probation, you will also complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. At all times while you're on probation, you're to have no violent contact with Kiaya White. That means there cannot be any physical or verbal altercations that get the authorities involved. No illegal drugs, and you're not to possess a weapon or firearm while you're on probation. Thank you.
Thank you.
Maybe.
Position number 1 and 2.
For Mr. Fletcher, his bench warrant is also null pros. All right, we are going to resume the plea hearing with Brittany Brown, who's at ACDC. She's been advised of her rights. She's been advised of the terms of the offer, unless there's been any modification. Have there been any modifications, Mr. McLean?
No, Your Honor.
All right, and Ms. Brown has also been placed under oath. So as I was saying, do you stipulate to the factual basis, venue, and ID, Mr. McLean?
We do.
All right. Ms. Brown, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood all the proceedings so far and your subsequent discussions with your attorney?
Yes, I do.
And are you still moving forward with entering a guilty plea to the charges listed?
Yes, ma'am.
Is anyone forcing you to take this plea?
No, ma'am.
And as I already indicated, your license will be suspended. Are you willing to accept that?
Yes, Your Honor.
And are you also willing to accept that you would have to give up your constitutional right to a trial in front of a judge or a jury? You will not be able to go back to court, face the judge, face your accuser, challenge the evidence that may be brought before you, have the ability to examine and cross-examine witnesses, present any defenses or mitigating factors, and have the state Carrie is burdened to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
And as you've already indicated, that you're willing to accept the consequence of also your license suspension. One of the requirements would be the surrender of your license to your probation officer at your first visit. Are you prepared to do that?
Yes, Your Honor.
Okay. How do you plead to one count of driving under the influence of alcohol, less safe, failure to obey a traffic control device, signs or markings, and possession of an open alcohol container from April 24th, 2022?
Guilty.
This will be your second DUI conviction. Your sentence for the DUI is 12 months to serve 26 days. Credit for time served 13 days. The remainder of the time will be on probation. You will report to probation next Thursday before 3 p.m. and the probation office is at 132 Mitchell Street in downtown Atlanta. While you're on probation for the DUI case, you will surrender your driver's license to the probation officer at your first visit. Your license will be suspended for the time that you're on probation. You will pay a $600 fine for the DUI less safe charge, do 30 hours of community service at any nonprofit agency that's not a school and not a church. You will also complete a risk reduction program, attend one MAD VIP panel, and submit yourself to an alcohol and drug evaluation and pay for any treatment or counseling that's required. For the count 2, failure to obey traffic signs or signals or markings, that will be a $265 fine. And for count 3, that will be a $265 fine. This will be concurrent to both count 2 and count 3 will be concurrent to count 1. Any questions, Ms. Brown?
I was just wondering about what was it that I paid to Fairburn when they gave me my release forms back to get my license. I thought
no
we
idea.
paid. You heard me?
Yes, I have no idea what you paid.
Oh, I thought it was the tickets.
That's the same thing I told her, Your Honor. Whatever she paid to the city of Fairburn, I said, once in a blue moon and very, very, very rarely, cities will make a mistake and take a fine on the running the red light, which then, yay, it's double jeopardy on the DUI. I said, but I don't know. Because
Okay.
I've been to Fairburn to research that point, and I said, if you want to see if there's a possibility of that defense,
All right.
investigate Fairburn. But
While upon your release, if you go to the city of Fairburn and you get a receipt that whatever you paid to city of Fairburn was a fine, you must bring that receipt to the probation office and you'll be given credit towards your fine payments.
Okay, thank you, Your Honor.
All right, thank you.
Excuse me, Judge, was that 30 hours of community service or 30
Yeah.
days?
It's 30 hours.
Thank you.
he needs to read those.
30 days will convert to 30 times 8, which would be 240 hours. Is that what you intended, Ms. Falk, or did you intend 30 hours?
No, because it's her second DUI, my understanding is it's 30 days of community service.
Okay, so let's amend that to 240 hours of community service. It's when y'all do it at 30 days, then it becomes, I just want to be sure. So
Understood, Your Honor. I'll make the corrections going forward.
thank you.
Let me point out something which is not going to change anything right now, but just very, very briefly. Her apartment number is on the police report. Her apartment number is not on the main address of the apartment complex to which the letter of court notice was sent, a photograph of which is in the return to sender item in Odyssey. So
Well, her bench warrant is null prost.
right. So if there's any break the state could give her on the 240, now would be a good time to say,
That's statutory.
Right, that's statutory. I have no control over that one, but
Don't we sometimes reduce to 120? Oh, well.
All right. Thank you. That concludes the
Thank you.
case. Jail court iPhone, who do we have?
We have position number 30, Mr.
Okay.
Sanders.
All right. Was that with Miss McLeod?
Judge, that should be my case.
All right. Does Officer Norris, are there any other cases waiting to be transported in?
Yeah, position number 13, but Mr. McLean has to continue interviewing him.
Mr. McLean, can you take this next case so that transportation is not held up?
Who's that? They already called like 3 times, so I'm pretty sure they're not.
Hey, which case is on the iPhone?
No.
No. The gentleman in the courtroom, is there a client who is waiting to be transported back to another jurisdiction?
Yes, Your Honor, we're discussing, I believe that he should probably be, he's got a felony case and he's got a misdemeanor case.
All right, are you ready to
I mean,
address that case so
no.
we can release him to transport?
Right, I think we need to consult with the felony lawyer. I think we should reset today till after the 26th.
So you want that case reset?
I would like it reset. I'm trying to explain to him that really, as a practical matter, he should not be pleading, although he should not be pleading today to something that would
Okay.
make him look bad for a felony.
Why don't you talk to him and Mr. Haddad will take the case at the jail court iPhone. I want to make sure that that he understands why the case is being reset.
Understood.
Jail court iPhone, that was position 30.
Yes.
And Mr. Haddad, that was your client, if I'm not mistaken?
Yes, it is, Judge. We're gonna waive arraignment and plead not guilty on him. We don't need, I'll file the paperwork, Judge.
All right, Mr. Zakiti, is it Zakeith? Zakeith Sanders, did I get the name right? Zakeith Sanders? I can't hear you, you're so far away from the phone.
Zakeith Sanders, yes, ma'am.
All right, so your case is 24 CR 102A, in which you were charged with battery, family violence, 2 counts of cruelty in the 3rd degree, and willful obstruction of an officer, and battery against a female who is vulnerable. With regards to these charges, 1, 2, 3, 4, 5 charges. It's 2 counts of cruelty in the 3rd degree. All right, with regards to these 5 charges, your attorney will be entering a not guilty plea and filing a waiver of arraignment, which means your case is going to be further noticed for trial. Do you understand, sir?
Do you understand? Yes or no?
Mr. Sanders, your attorney is Jawan Haddad. Do you see him on the screen? Do you see
Yes,
your attorney? All right.
Yes, I'm on the screen.
All right. That's your attorney. And I just want to make sure that you understand that your attorney is entering a not guilty plea on your behalf, and your case will be scheduled for trial. So that do you understand that?
Yes, I understand what a trial is.
Okay. And I believe that's all we're addressing in your case. Is that correct, Mr. Haddad?
That is correct, Judge.
All right. That concludes position number 30. Thank you, Mr. Sanders. You will get notice as to your trial date. Thank you.
All right, next we have position number 29.
All right. That's also Mr. Haddad's case. This is Bonanza Robinson. Mr. Robinson, you've got a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Haddad. With regards to this case, Mr. Haddad has indicated that this is also going to be a waiver of arraignment and an entry of a not guilty plea. Would that be correct, Mr. Haddad?
That is correct, Judge. Thank you.
All right. Mr. Robinson, your attorney is entering a not guilty plea on your behalf, and your case is going to be scheduled for trial. You will get notice for your trial date as soon as it's scheduled. Do you understand, sir?
Yes, sir.
I'm sorry, was that a yes?
Yes.
All right, thank you. Best of luck.
All right, we have to go back to I have to go back and get Mr. Chastain. Is everybody ready for him?
Could you give me the position number?
Position number 5, I'm sorry.
Repeat?
Position number 5,
5.
yes.
I just want to make sure that's not Miss McLeod's case. I
It
think,
is, Your Honor.
all right, and she has not appeared at 11 and it's already 11:15. I'm going to reset this case. Let me see. Yeah, I'm going to reset this case to next week, which is January 25th.
Okay.
For Miss McLeod to appear. I'm looking at the recommended plea offer, and that's not going to prejudice the matter. Thank you. And were there any other cases, officer, at jail court Eichler?
Yes, we have to go down to MOU. Just give us about maybe 10 minutes.
Okay, thank you.
Okay. Yeah.
Mr. McLean, are you ready to address? No? Okay. I have a bench warrant matter also that's scheduled for 11 o'clock. And unless Mr. McLean's ready to address the clients whose cases might be reset.
Your Honor, the Jamarius Jackson case is one where we need to ask the court to reset that past January 26th. So we need to find out if he can get a bond on his felony case. And that way he's in a position of judging whether he can afford to make a bond in both cases together. Right now, on that January 26th hearing, until then, he has a bond.
I can reset the case to February 1st, 2024.
Excellent.
And
Position,
Your Honor, I'm sorry, which position was that?
position 13,
Okay.
reset
February 1st.
to February 1st, 2024 at 9 a.m.
Thank you, Your Honor.
Okay. I have a 11 o'clock domestic violence motion to set aside a bench warrant for LaMarcus Deontay Ames.
Your Honor, that was addressed on Tuesday. I'm
Oh.
kind of, I think it may have been doubled, but we did address that and the bench warrant was reset, is my understanding, on Tuesday.
Oh, it's not being done.
Okay. Yeah, I do see it had a Tuesday date and then it had a January 18th, today's date, and now it's got a bond forfeiture date of May 8th. So was the bench warrant set aside, or we just moving it forward to May 8th with
It was in fact set aside by Judge Williams on
Okay.
Tuesday.
Okay.
I don't know, but I don't know if the actual entry of the order has been put into the system yet.
No. And he's got a bond forfeiture. So as far as this case is concerned, it's still flashing as a bench warrant. So if he gets picked up today, he will be arrested. So who represented him on Tuesday? Mr. McLean, Mr. Haddad? Do you know if he had a public defense attorney?
I'm sorry, on the bench warrant?
Yeah.
Yes, it was Javier Trejo.
All right, could you please let Mr. Trejo know that the order, if Judge Williams set aside the bench warrant, it's not showing up. So in Odyssey, it still shows as an active bench warrant. So if he happens to be,
Right, I'll email him.
shopping at Macy's and something goes wrong, he might be getting an invite to the jail. So,
I'll email Mr. Trejo right now, Judge.
all right, so thank you.
Thank you.
All right, that leaves us with our competency calendar. Who needs to be in the breakout with me? Ms. Paul?
There's nobody here in the courtroom.
Yeah, we normally do the competency calendar in a separate breakout session. I normally have Rachel Abden
Right,
or
I don't see Miss.
Ms. Burgess.
I'm covering for Rachel.
Oh, okay.
And I'll step in the back and address this, Judge.
So you'll be on your laptop?
I will be, Judge.
Okay.
And Your Honor, can we go over the calendar before we go into the competency? So that anybody who was on the main calendar can be excused?
All right. And Mr. Haddad, is Mr. McLean there?
He's here, Judge. I can go over the calendar. I mean, it won't be take too long. It's up.
All right, position number 1, Brittany Brown is null. Well, let me do the null cross, the add-on first. On the add-on, it was Fletcher, and that was a plea, and the bench warrant was null crossed. On the main SAP calendar, position 1 was null crossed, position 2 was a plea, position 3, Carmen Carter was released. Position 4, same announcement released. Position 5 is reset to January 25th. Position 6, Kristen Collier was released. Position 7, Antoine Copeland was released. Same announcement for position 8. Position 9 is arraigned. This is a waiver of arraignment and further notice for trial. Position 10, y'all are asking for a 1-week reset, 10 and 11. No, just 10. Yeah, 10 and 11. Santino.
That is correct, Your Honor.
All right. Any objection, Mr. McLean?
No, Judge.
Okay, so this case, positions 10 and 11 are reset to January 25th. Position 12, Larry Gillot is supposed to be a plea. And this is position 12. Position 13, Jackson is reset to February 1st, 2024. 14, Johnson is, this is Jartavius Johnson, position 14, reset to January 25th, 2024. Position 15, Gary Jones is released. Position 16, Gerald Masorius is, y'all still want a 1-week reset to January 25th?
Yes, Your Honor, that is correct. He has multiple cases and we want to consolidate them.
Okay, position 16 is reset January 25th. Position 17 is for a waiver of arraignment. That's Rodriguez Milner. Waiver of arraignment will be filed and is further notice for trial. Position 18, Eric Moore is a 2-week reset. Y'all want to reset it to February 1st? Mr. McLean, any objection?
No, it'll be fine, Judge.
All right. Position 18 is reset to February 1st, 2024. Position 19, a waiver of arraignment will be filed and that case is further notice for trial. All right, position 20, Odom, it was a plea. 21 is null cross. 22, outlaw. Mr. Haddad?
Your Honor, I'm asking a reset, I can't remember if it's next week or the week after. He's got some felony charges. I need to coordinate with the felony attorney, Judge.
Okay. Outlaw will be reset to January 25th, which is next Thursday. That's for position 22 and 23. 20 and 24, excuse me, January 25th. 25, Fermenter was a plea. 26 is null cross. 27, Kevon Pope is a null cross because we took a plea on Pope in 28. 28 is the plea. 29, Robinson was a, I think that was a waiver of arraignment and further notice for trial. 30, Zakeith Sanders, that's going to be also a waiver of arraignment and further notice for trial. And 31, Veronica Smith, position 31 is a plea. Position 32 is a waiver of arraignment and further notice for trial. And position 33 is a null cross because of the plea in position 31. Position 34, Danny South is a plea. 35, Dominic Tatum is to continue to reset to January 25th. That was for Tatum. Anthony, and same thing for position 36, reset to January 25th. 37, Townsend was a plea. 38, Williams was a plea. 39 is Mr. Antonio Willis, and that's a waiver of arraignment to be filed and further notice for trial. Probation revocation, if y'all want to go over that, position 1, Chambers, was to continue on probation, and that closes out position 2. Position 3, Henderson, is time served, and that closes out position 4. Position 5, Rashad Hill, is continued on probation. That closes out position 6. This is the probation revocation matter. Position 7, Lee, is the probation is time served, and that closes out position 8. Position 9, Wilcox, is continued on probation, and that closes out position 10. And then position 11 is continued on probation.
Your Honor, position 12, is he here? I mean, at the jail?
Well,
To
I have
address
someone
his
at
case?
jail court iPhone, so let's
Wow.
find out.
Well, this, jail court iPhones, we have position number 16.
Hello.
All right. Position 16 is Gerald Moserius.
Yes.
Mr.
Yes,
Moserius, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your attorney is Mr. Michael McLean.
Yes, sir.
Mr. McLean, this case is going to be reset to January 25th.
Understood, Your Honor. As it's being reset to January 25th, when I saw him, he's in the medical observation unit, Your Honor. He's already had his surgery. He's currently in chemo. After chemo will come radiation. He was simply asking the court to consider a signature bond so he could do these medical treatments from home at Grady because he's hurt.
I have amyloidosis, which is a type of cancer leading to multiple myeloma, which affects my lungs, kidneys, and heart. I was evaluated for this here. I have to be extremely isolated and be in a sterile environment for me to, because during chemotherapy, my immune system is weak. So it's extremely strenuous. And I've missed about 4 appointments because I simply don't have control of my environment. It's extremely strenuous, especially being in here, having to worry about my immune system and having to worry about making it to Grady and having to worry about all these other things. It was according to my knowledge that the state was.
Mr. Moserius, let me just clarify one thing. As far as the criminal trespass charge that you have with us right now, position 16.
Okay.
I don't see a bond. I see you have a signature bond.
Right, Your Honor, he's not in jail because of us. He's in
I
jail
know.
because of his 23 case, 23
Understood.
CP case.
Understood.
Okay, then I need to get the lawyer on that, involved on that in their courtroom. If
All right.
if we're already on signature bond on this, then I don't have any purchase on getting his freedom today.
He's got a $1,000 surety bond in the felony case. This case that's before us right now is not holding him at the jail.
He's got a $500 SOB through the jail on this case issued by Judge Morrow on January 2nd.
Very good.
All right.
Thank you.
Mr. Jackson, this is a matter that you would have to address in felony court, in Superior Court, not with us. And in that respect, are we still resetting it to January 25th, or would you like to file a waiver of arraignment?
We're resetting it, I believe. That's we're just gonna do this on the 25th.
Correct, Your Honor. I'd like to try to get rid of both of his cases if possible.
All right, thank you. Thank you, Mr. Jackson.
Oh, that's Mr. Massarira.
Oh, I thought his last name was Jackson, no?
No, Massarira. He's 16. Jackson was 13.
Oh, I bet, I'm sorry about that. Gerald Masseria. Yeah, Mr. Masseria, we'll see you on January 25th. But you have to work with your Superior Court public defense attorney.
Thank you.
Thank you.
Now, number 12 is a plea.
We have to go to 3 North to grab position number 12.
All right, and that's the only case left.
Right. Mr.
Okay.
Goodbye, it's also a MARTA case.
Right.
And yeah, all right. Okay, Mr. Haddad, are you at your laptop?
I am, Judge. I'll walk.
All right, Miss Grace, if you want to place me and Kia Burgess and Mr. Jawan, PD Jawan Haddad, and Miss Kasha and Miss Falk in a breakout, please.
You just want to sleep? Yeah, same here. Yep, I figured. Mr. Goulet, is that you in medical?
Yes, this is position number 12.
Larry Goulet?
Yes, sir.
Mr. Goulet, when the judge comes back on the video, she will be prepared to take a guilty or not guilty plea from you. As I understand from talking to you last night in the jail, you wanted to do a negotiated plea of guilty today. Is that correct?
Yes, sir.
All right, let me go back and make sure that I have the offer in front of me here. Let's see, number 12. 12 months to serve 180 days, credit for time served 64 days, balance on probation. Stay away from all MARTA because of your lifetime ban. Your lifetime ban already exists. This court simply reminding you that you already have a lifetime ban. Is that correct or is that incorrect?
I believe it's correct.
Okay, so you stay away from MARTA forever. Now, are you
Yes,
from,
sir.
you from Georgia?
Yes, sir. I'm from Atlanta.
Okay, now it's going to be hard on an Atlanta man not to use Atlanta's own public transportation system. That means no buses, no trains. You can't even sit at a bus stop.
Yes, sir.
Okay, we understand each other.
Yes,
No
sir.
no contact with Adriana Watkins. You don't know Miss Watkins, right?
No, sir.
All right, so if you recognize Miss Watkins, you walk away and stay 200 yards away from her. If you ever run into her again, I don't know that you even know what she looks like. If you don't know what she looks like, then don't try to look her up. Just forget.
Yes, sir.
But if you see Miss Watkins, or if you see some lady pointing at you, acting nervous, then maybe you ought to just walk 200 yards away and stay away from them, okay?
Yes, sir.
Now, you're gonna have to do a mental health evaluation, which means talking to a psychiatrist or a psychologist. You can get that done at 10 Park Place at Grady.
Yes, sir.
You already go to 10 Park Place, right?
Yes, I just haven't been in a while though.
Yeah, tell them you need a fresh evaluation so that you can get on your meds the right way.
Yes, sir.
That's all you gotta do. Now, the 180 days divided by 2 is gonna equal 90 days. The 90 days you have to do, you've already done 64 of them. So that means that you've only got how many to go? What is 90 minus 60? That's 30. What is 4 off of that? 26. So you only have 26 days before you start this probation. And
Yes, sir.
the probation is to make sure you get that evaluation. You're not gonna pay a fine. You're not gonna do community service. You're just gonna get that evaluation. But your only requirement is to show up at probation and get the evaluation.
Yes, sir.
So you're gonna be on probation.
Yes, sir.
Now, probation costs $49 a month,
$49.
every month.
Okay, that's fine.
Do you get a disability check?
Yes, sir.
Has it been cut off yet?
Yeah, I believe so. Yes.
All right, how soon are you gonna be able to get that check cut back on?
I could get it cut back on within maybe like not too long after I go to the office. I don't think it'll take that long.
You think it'll take 2 weeks or 30 days or what?
Probably 2 weeks.
All right, we'll get that check cut back on. If they can't cut the check back on real quick, do you have somebody you can borrow $49 from to pay the probation fee?
Yes, sir. My father, Larry Gillette Sr.
All right, what is Larry Gillette Senior's phone number?
The 678-887-3880.
$287?
No, 678-887-3880.
Hey, Mr. Larry Gillette Senior? I have your son on a video screen. My name is Michael McLean. I'm an attorney with Fulton County Public Defender. We're about to take a guilty plea on a case, a one-count misdemeanor, and he is going to be reminded by the court that he can never use any MARTA. He's got a lifetime ban for MARTA. And so that means he can't even be at a bus stop.
Mr. McLean, we are back from the main session. Were you talking to your client?
Actually, I was talking on the speakerphone with my client's father, Your Honor.
Oh,
And
I see.
I think we're ready to go forward. If the court doesn't mind, I'll leave that open so the dad can hear the proceedings.
Okay, that sounds good. Thank you. I'm assuming we are addressing Larry Goulart on position 12.
Yes.
All right. Mr. Larry Goulart, my name is Judge Lal. Do you see me?
Yes, ma'am.
Okay. Your case number is 24 CR 312E, in which you were accused of criminal trespass from November 16, 2023 at a MARTA station. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. This is going to be a negotiated plea hearing. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what is the recommendation for Mr. Goulart?
State's recommendation is 12 months probation, serve 180 days, credit for time served 64 days. That is from January 16th of 2024. Balance probated, stay away. He has currently a lifetime ban for MARTA, so stay away from all MARTA concurrent with that lifetime ban, and no further contact with Adriana Watkins, as well as MHET. We would like to sound for Miss Adriana Watkins, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
For the purpose of the plea, we do so stipulate.
All right. Ms. Watkins, I don't see anyone here called Adriana Watkins. Okay. Mr. McLean, your client accepts these terms?
Yes, Your Honor, I believe my client is fully competent and he understands the court proceedings. He does get services at 10 Park. He will go back there and get that evaluation done, Your Honor, if a fresh one is needed. He will stay on meds.
Mr. Goulart, have you consumed any medication or alcohol recently?
Ma'am, I've been on mental health medication since I've been in jail.
Okay. And after consuming that medication, are you still able to understand the proceedings?
Yes, ma'am.
And are you able to understand your lawyer?
Yes, ma'am.
Are you satisfied with his services?
Yes, ma'am.
And you understand that today you are considering entering a guilty plea to a charge of criminal trespass at a MARTA station?
Yes, ma'am.
And do you understand that you have a lifetime ban from using MARTA services?
Yes, ma'am.
What does that mean?
Never to go on MARTA premises ever again.
If you decide to move forward with this plea, you would have to give up your right to have a trial. You will not have your day in court where you get to face a judge or a jury. You will not be able to have the assistance of counsel to present your arguments, present your defenses, present and confront your accuser, as well as challenge the witnesses brought before you. You will also have to give up your right to have the prosecutor try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 180 days. Credit for time served, 64 days. You have about 25 to 26 more days left to serve at the jail.
Yes, ma'am.
Once you've served this additional time, you'll report to probation. Probation is located at 132 Mitchell Street in downtown Atlanta. You have to report to probation at the first business day after you're released from jail.
Yes, ma'am.
While you're on probation, you must complete a MH evaluation. And you can do that at the facility you're comfortable with, or you can go to Grady. And if the evaluator says you must take any treatment or medication, you must do so. Do you understand?
Yes, ma'am.
At all times, you are to be compliant with your treatment and medication. You cannot skip your medication and you cannot skip your treatment. Do you understand?
Yes, ma'am.
All right. After you've completed your evaluation and any treatment, I will place your probation on non-reporting.
Yes, ma'am.
But do you agree with me that you cannot return to any MARTA bus station, any MARTA train station? You cannot go to the parking lot. You cannot go to the sidewalk. You cannot be under the bus shelter. You cannot use their bathrooms. And you definitely cannot use their trains and buses.
Yes, ma'am. I fully understand.
All right. Your father is listening to all this. So make sure, because if you don't understand it and you get in trouble again, not only will you be facing me, you'll be facing your dad as well. So you decide which is worse.
Your Honor, and I mean, I mentioned, my understanding is this lifetime ban from MARTA pre-existed today.
I've just been informed of it, so your guess is as good as mine.
No, I mean, that's what I've been told, so I just want to put that on the record.
Well, okay. So it pre-existed prior to this case, then it's probably resulting in the arrest. Okay. Thank you, Mr. Gillard. Best of luck. You have additional time in the jail, then you'll be released. Don't forget to report to probation and the first business day upon release. Thank you.
Yes, ma'am.
All right, ladies and gentlemen, that concludes our SAP calendar for today. And we are halfway through the month of January. Isn't it amazing how time flies?
It is.
Okay, folks, I will see everyone at I'll see some folks at 2 o'clock for the exciting and revigorating C calendar. Makes your blood flow faster, Mr. McLean, so.
I'll be missing that C calendar today. Your Honor.
Oh, sort of thing. That's all right.
I'll just have to go back to the office and fill out a few pleas.
Well, you can always join us at Zoom. That's okay. Thank you. All right, everyone, have a good morning. Thank you.
Thank you.
Thank you. Please send over all paperwork.
Oh,
and
yeah.
all process.